Morning. Are you Harold Middleton?
Yes.
All right. So this is People v. Harold Middleton, file 25-70550FH for arraignment. Counsel, you want to state your appearances, please?
Anthony Julia on behalf of the people.
No, not Governor, for Mr. Middleton, who appears remotely from the Chippewa County Jail.
Okay. Have you had a chance to review the charging document with your client?
I have, Your Honor. He did not want to waive any sort of formalities or readings. At this time, he wants a formal arraignment conducted.
No problem. All right. Mr. Middleton, are you Harold Stanley Middleton III?
Yes.
All right, Mr. Middleton, you are charged in a felony information with 3 counts as well as a habitual 4th notice. In count 1, breaking and entering a building with intent. It alleges that on or about May 6th, 2024, in the village of Wolverine, Sheboygan County, that you did break and enter a garage located at 5734 Cedar Street, Wolverine, Michigan, 49799, with the intent to commit the crime of larceny therein. That would be a felony punishable by a maximum of 10 years in prison. The prosecutor has filed a notice that you have been previously convicted of 3 or more felonies or attempts to commit felonies, in that on or about April 19th, 2022, you were convicted of possession of methamphetamine in the 50th Circuit Court for Chippewa County, state of Michigan, and on or about April 19th, 2022, convicted of malicious destruction of fire or police property, again in Chippewa County, state of Michigan, and on or about April 23rd, 2024, you were convicted of maintaining a drug house in the 50th Circuit Court, again for Chippewa County, state of Michigan. With that habitual offender notice, that would increase, in the court's discretion, the maximum penalty for the B&E on count 1 from 10 years to a maximum of life in prison. Count 2, larceny, $1,000 or more but less than $20,000, alleges that on or about the same date and location as in count 1, you did commit the offense of larceny by stealing a 2010 Ford F-150 that belonged to a Lance Michael Harmer. The value of the property stolen was $1,000 or less, $1,000 or more, but less than $20,000. That would be a felony punishable by a maximum of 5 years and or a $10,000 fine, or 3 times the value of the property stolen, whichever is greater. However, with the habitual 4th notice, that would again increase the maximum penalty in the court's discretion to life in prison. Count 3, motor vehicle unlawful driving away, alleges that on or about the same date and time as counts 1 and 2, and at the same location, you did willfully and without authority take possession of and drive or take away, or did assist in or was a party to such taking, possession, driving, or taking away of a motor vehicle, to wit, a 2010 Ford F-150 belonging to another, to wit, Lance Michael Harmer. That's a felony punishable by a maximum of 5 years in prison and a suspension of your driver's license by the Secretary of State. But again, with the habitual 4th notice, in the court's discretion, the maximum penalty could be increased to life in prison. Mr. Middleton, do you understand the maximum penalty of the charges against you, or do you have any questions for me or your lawyer about that?
No, I understand.
Okay, and Mr. Nightingale, how does Mr. Middleton wish to plead to those?
Not guilty.
Counts? Okay, we'll enter a plea of not guilty, Mr. Middleton, as to all 3 counts, and Mr. Nightingale is a forensic center referral requested?
No, Your Honor.
What would be the estimated length of trial?
I would say 2 days.
Okay. And I did see there was a preliminary examination in this matter and a transcript prepared. Are you anticipating motion to quash?
I am, Your Honor. I will file it as soon as I can get it drafted.
Okay, we can set this then for a docket call, and you can notice up a motion to quash on September 30th at 10:30 a.m. And is Mr. Middleton expected to still be in the Chippewa County Jail at that time?
He will be in the jail still at that time, yes.
Okay, we'll have that be a Zoom appearance on his part. Anything further from the defense?
No, Your Honor, thank you.
Anything further from the people?
No, thank you.
Okay, Mr. Middleton, your lawyer's going to file a motion challenging at least 1 or more of the charges up here, and we're going to hear that motion and have you zoom in on September 30th at 10:30 in the morning,
I
right?
would like to be there. I could,
You'd like to be there in person?
yeah,
All right, well, I'll have you talk with Mr. Nightingale about that between now and then. I think it's not required that I would have you be in person for that, since it's just some legal arguments. But if he wants to make that request, I'll discuss that with him and the prosecutor beforehand. All right, otherwise we'll
Right.
probably have you zoom in. I'll see you then, sir.
and I would like my discovery pack as also.
Okay, Mr. Nightingale, have you been provided with discovery?
Yes, Your Honor.
I would
Mr.
like
Middleton,
my
it should be on the way to you.
transcripts from my
I think it got
prelims,
mailed
too.
out late last week.
So, Mr. Middleton, when you're represented by an attorney, then the prosecutor doesn't present it to you directly. They give it to your lawyer. He's indicated he has it and he's getting a copy out to you. Anything else?
No, just waiting on my discovery pack that I've been waiting on for a while now.
Okay.
I mean, it
All
is
right,
my
well, you
right
should-
to have it, so,
Yep, and your lawyer's got it and he says that it's on its way to you.
okay. I would like
All
my
right,
other,
let's-
my transcript for my preliminary exam too. I'd like all that too.
Okay. Well, again, that's stuff you'd request from your lawyer, not from me. He's got it
And
and
I've
he's
been
representing
requesting.
your interests. Okay. All right, you have a good day, sir.
Yep.
I'm going to call Mr. Warner's case. It's the People versus Keegan Warner, file 25-7004FH. Got Mr. Warner in the courtroom with his lawyer, Mr. Andriaki, the prosecuting attorney, Ms. Goodrich for the People. We're here for a docket call. Mr. Andriaki, how are we proceeding, sir?
Your Honor, with me entering a plea if I may approach, but ask to take a look at it.
Mr. Warner, would you please stand and as best you can, raise your right hand for me, sir? Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
You can be seated. Are you Keegan Ray Warner?
Yes, sir.
Okay, Mr. Warner, a guilty plea hearing is an important event. It includes the waiver of constitutional and other rights that you have. So I want you to listen carefully. At any time, if you have a question, ask me. I'm happy to answer. If you need a minute to talk to your lawyer, you just let me know. We're happy to give you that time. Is that all right?
All right.
Now, I have to advise you of the maximum penalty that you could face for the charges you're offering to plead guilty to today. And that would be counts 3 and 4. Count 3 is using a computer to commit a crime with a maximum of 4 to 10 years of the underlying crime. That is a felony punishable by 7 years and or $5,000 fine with reimbursement for the costs for government expenses and a discretionary consecutive sentence for the underlying conviction. Count 4 would be the underlying conviction accosting a minor for immoral purposes. That would be a felony punishable by a maximum of 4 years and or $4,000 fine. There's mandatory AIDS and STD testing. And there's it would be a tier 2 offense under the Michigan Sex Offender Registration Act, unless you have a prior tier 2 offense conviction, in which case it would be a tier 3 offense. So the discretionary consecutive means that the maximum exposure you would have would be the 7 years plus 4 years or 11 years maximum in the state prison. Mr. Warner, do you understand the maximum penalty allowed by law for those charges?
Yes, Your Honor.
Are you on probation or parole anywhere?
Not currently.
Okay, were you on bond for any other cases at the time of this incident back in October 2024?
No, Your Honor.
Okay, did you read and understand the rights listed on the advice of rights form?
Yes, Your Honor.
And did you sign that form today?
Yes, Your Honor.
Do you have any questions for me or for your lawyer about any of those rights?
No, Your Honor.
Do you understand that if you plead guilty, you'll give up all those trial rights and you won't have a trial of any kind?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes, Your Honor.
All right, if I accept your plea, you're giving up any claim that the plea was caused by any threats or by any promises that are beyond the terms of the agreement. Do you understand that?
Yes, Your Honor.
Also, when you plead guilty, you give up the right to appeal. And if you wanted to appeal, you'd have to seek permission to appeal. You would do so by filing an application. Court of Appeals would not have to hear your appeal at all. If they did decide to hear your appeal, the types of issues that you could raise are very limited after a plea, much more limited than if you were convicted after a trial. Do you understand that?
Yes, Your Honor.
The plea agreement provides that in exchange for your plea of guilty to counts 3 and 4, the prosecutor will dismiss the remaining charges. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Andriaki, is that a full, fair, and accurate statement of the terms of the agreement?
Yes, Your Honor.
Ms. Goodrich?
Yes.
All right, Mr. Warner, other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, Your Honor.
Has anybody threatened you in any way to make you do so?
No, Your Honor.
Is entering this plea your own free choosing?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 3, using a computer to commit a crime punishable by at least 4 years?
Guilty.
How do you wish to plead to the charge in count 4, accosting a minor for immoral purposes?
Guilty.
So, Mr. Warner, back on October 1st of last year, 2024, did you have some communications with a person who was located in Sheboygan County?
Yes, Your Honor.
Was that person less than 16 years of age?
Yes, Your Honor.
Did you know that that person was less than 16 years of age?
Yes, Your Honor.
Were you using a computer program or a computer device to communicate with that person?
Yes, Your Honor.
Were you situated in Sheboygan County or no?
No, I was in Abbott County.
Okay, but the person you were communicating with was in Sheboygan County?
Yes, Your Honor.
And during the course of that communication, did you have some communications of a sexual nature with that person?
Yes, sir.
Did you ask that person to engage in any sexual activity with you?
Some pictures. Yes, Your Honor.
Okay. And you asked them to send photographs that would be of a sexual nature
Yes, Your Honor.
of them in an unclothed state?
Yes, Your Honor.
Okay. Mr. Andriaki, are you satisfied with that factual basis?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Mr. Andriaki, are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe I fully complied with the requirements of MCR 6.302?
I do, Your Honor.
Ms. Goodrich, on both those questions, your thoughts?
Yes.
All right, and Mr. Warner, I find that your plea is knowingly, understandably, and voluntarily made, and that there's a sufficient basis in fact and law to believe that you are guilty of those offenses. So I do accept your plea. You'll have to cooperate with a pre-sentence report where you'll be interviewed by an agent from the Department of Corrections so they can make recommendations about what I should do with you. I would presume you want me to know more about you than what I just learned right now. There's 2 ways that I learn about that. One is through you and your attorney at the sentencing, and another is through this pre-sentence report where I learn more about who you are. So we'll schedule sentencing for September 30th. Mr. Andriaki, morning or afternoon work better for you?
Afternoon would be best, Your Honor.
How about 3 p.m. okay?
Perfect, Your Honor.
So we'll schedule your sentencing, Mr. Warner, for September 30th at 3 p.m. Anything further from the defense,
No, thank you, Your Honor.
from the people?
No, Your Honor, thank you.
All right, we'll see you then, sir.
Thank you, Your Honor.
Got a phone calling in. I'm going to see who this person is.
All right, let's talk about that. The arraignment of People versus Harold Middleton and the plea hearing for People versus Keegan Warner had very different tones. But both gave a look into how the court balances procedure, rights, and accountability. Judge Aaron J. Gauthier was steady as ever, professional, patient, and thorough. Even when the defendants themselves showed very different attitudes toward the process. Harold Middleton's case was all about formalities and posture. He appeared remotely from the Chippewa County Jail and made it clear he didn't want to waive any readings, he wanted the full formal arraignment. Fair enough. The judge carefully walked him through 3 felony charges, each carrying serious penalties, especially with the habitual fourth offender notice that technically put life in prison on the table. Middleton listened, said he understood, and entered not guilty pleas across the board. His defense attorney flagged plans to challenge the charges with a motion to quash, which set the stage for more legal wrangling down the line. Middleton also showed a bit of impatience about receiving his discovery packet, insisting it was his right to have it in hand. The judge kept the explanation simple. Discovery flows through his lawyer, not directly to him. It wasn't confrontational, but you could sense Middleton's frustration simmering under the surface. Still, Judge Gauthier didn't let it throw the hearing off course. He acknowledged the request, reminded Middleton of the process, and moved on. That's the kind of steady handling that keeps a hearing on track without escalating small sparks into bigger fires. Keegan Warner's plea hearing, by contrast, was more straightforward and, in some ways, heavier. He stood in court, raised his right hand, and answered the judge's questions with a string of "Yes, Your Honor," responses that showed he understood the weight of what he was doing. Judge Gauthier carefully explained the maximum penalties, the rights Warner was giving up, and the fact that after a guilty plea, appeals are much more limited. The plea agreement reduced the charges,